再望過多少少，我望下呢度啊，得埋。頭先就望到間啦。再側邊跳低啲，反光嘅，OK。得埋呢度，得埋呢度。再將呢度唔該。邊唔該。好麻煩，時候去翻中間啦。唔該。好呢度。係講我呢度。
OK。
冇啦，你咁樣影咪仲好。
OK 嘛？
特別啲啊嘛。
好啦，咁就記者會正式。All right, let's begin the press conference. Welcome to the press conference on proposed guidelines on election-related activities in respect of the rural representative election. We have on the stage Chair of the Electoral Affairs Commission, Mr. Justice Barnabas Fong Hua, and Mr. Arthur Look, Senior Counsel, Professor Daniel Sheck, and Ms. Rachel Yu, Acting Assistant Director of Home Affairs, and Ms. Carmen Can, Principal Liaison Officer, Home Affairs Department. There will be two parts to this press conference. Mr. Justice Barnabas Fong will brief you on the details of the proposed guidelines, and there will also be a Q&A session afterwards. Good afternoon. Welcome to the press conference. The Electoral Affairs Commission today publishes the proposed guidelines on election-related activities in respect of the rural representative election, or RRE, to be held today at this year and subsequent elections. The public consultation period starts today until the August 9th. The Electoral Affairs Commission is an independent, non-political commission, and we are empowered by the law to publish the proposed guidelines, basically to let everyone know the relevant legislation they should follow. We also include some best practices to make sure that they won't inadvertently be caught by the law, and to ensure that the election will be held in a fair and partial manner. The RRE, the rural representative election, will be held in the beginning of next year. At the moment, there are 709 villages and 1,484 village representatives will be returned, comprising 695 resident representatives and 789 indigenous inhabitant representatives. In addition, 39 and 17 Kaifong representatives will be returned for the market towns of Cheungchao and Pingchao, respectively. And according to established practice, before each election, the Electoral Affairs Commission will review and update the guidelines. And this exercise is in line with the existing practice, and the proposed guidelines are prepared on the basis of the 2018 guidelines with the appropriate and necessary amendments. In fact, after Chairman's forward in the document, there is an index providing all the amendments made. But let me brief you on the major amendments. These amendments can fall under three major areas. First, we need to have the amendments to reflect the relevant electoral laws. And since the guidelines were last issued in October 2018, there have been 6 amendments of legislation or subsidiary legislation relating to the rural representative election, including the registration of electors and other matters. The second category reflects the amendments to electoral arrangements. This election will be the last election in the whole election cycle. So in relation to revised guidelines on election-related activities in respect of the chief executive election, etc., relevant amendments will also be included in this election guidelines as well. The third category is to make reference to operational experience with the case laws so that there is greater clarity on the electoral laws. Comparing to the previous guidelines, there are 46 amendments basically falling under the first and the second categories to reflect the relevant legislative amendments and to bring the electoral arrangements in line with those for other elections. Among the amendments, one requirement is for submission of address proof for change of registration particulars. This is where the law stands at the moment, as time is needed to verify the address proof. The cycle would be advanced 1 month forward, meaning that the deadline for registration of electors will be advanced by 1 month to the 16th of June so that more time can be allowed for the office to verify the address. In relation to inspection of the register and the persons eligible to do so, we also make it clear that eligible candidates and the media can inspect the register. However, in light of the unique nature of rural representative elections and the associated persons involved, we also add Hangyi-Kuk, the relevant rural committees and indigenous villages, to the eligibility list, and we believe that by including them in the eligible persons for inspecting the register, it would be beneficial. The law also provides circumstances under which a person shall be disqualified from being nominated as a candidate or being elected as a rural representative for a rural area. And if the person declines or neglects to take a specified oath or be in breach of the oath, fails to fulfill the legal requirements and conditions on upholding the basic law and bearing allegiance to the Hong Kong SAR of the People's Republic of China, shall be disqualified from being nominated as a candidate and from being elected, and that he must not stand in an election in the next 5 years. And in fact, the relevant bill was passed on the 6th of July in the Legislative Council. And as per the existing practice, the person must sign a declaration in a nomination form stating that he will uphold the Basic Law and pledge allegiance to the Hong Kong SAR, and otherwise a nomination will not be valid.
In past elections, we used the confirmation form to ensure all candidates fully understood the relevant legal provisions. In the 2023 ROE, the nomination form has been changed. Legal provisions in relation to upholding the Basic Law will be clearly stated in the nomination form. Reference of upholding the Basic Law and bearing allegiance to the HKSAR as stipulated in the Interpretation and General Clauses Ordinance Cap 1 will also be added to the nomination form. To ensure that the candidate fully understands the legal requirements and responsibilities concerned when he or she signs the nomination form. Therefore, because of this, the legal requirements have been put into the nomination form, and therefore asking the candidate to sign a separate confirmation form is not required. In the present electoral arrangement, there is quite a substantial change. In previous elections, the counting of the votes of village representatives for villages within the same rural committee was conducted centrally in the same counting station. The returning officer was responsible for counting the counting arrangements. To make the counting more effective, the law has been amended. The HAD can set up polling counting stations. The ROs powers would be shared with the PROs so as to conduct counting at the polling station, and that avoids the delivery of ballot papers from the voting station to from polling station to counting station, and speed up the counting process. The Director of Home Affairs may require subsidized schools and institutions to lend out their premises as counting stations. This is to ensure that we have polling and counting stations near the voters. We have also queuing arrangements for those 70 or above, pregnant women, or the disabled, or the frail and ill. They have difficulties in queuing for a long time. We can give them priority in getting the ballot papers. Just like other elections, if you have lost in the past, if you lost your ID, you had to provide an alternative. That is the memo of lost property and other documents. In the past, the person was required to produce a copy of his or her ID. We have waived that requirement because people may not have a photocopy of his or her own ID. So we accept the memo of lost property provided by the police. And the law also allows the adoption of electronic roll register system for issuing ballot papers at polling stations. But this is only a standby arrangement. In 2023 elections, it will not be used. According to our experience of the recent Electoral election, the polling stations in remote areas had difficulties because of network coverage. If there are many remote villages which are not covered adequately by the network, then, and in fact many ROE or many village representative election polling stations will not be adequately covered. We have already asked experts to consider upgrading the coverage with the improvement of technology with confidence that it can be done in the future. But to repeat, in terms of rural representative elections, most of the polling stations do not have many voters, so the problem will not be very serious. In the past, the returning officer will provide the ID of the election representatives. We have looked into that. We do not require the details to be given to all candidates. As for some case laws, in your election advertisement, you need to be based on facts. We made reference to the case law to avoid unnecessary litigations. Like other elections, a third party, say the candidate who is not a candidate or not a representative, if there is a advertisement, if it only involves the internet fee or the electricity charge, that is not against the law. That is exempted. But if one is a candidate or representative of a candidate, if one publishes electoral election advertisement on the internet, that the cost has to be reported. The candidates have to be very careful in handling voters' information. Whether the information is obtained through other channels or through us, the voters' information can only be used in the rural representative elections and nothing else. It cannot be used for commercial purpose, of course, nor should it be used in the next election. There were also cases in which some candidates were not able to issue emails to many voters because the ceiling has been met. So liaison has to be made with the service providers in order to lift the ceiling on the cap on the number of emails. As for election meetings, in the election meetings, if food and drinks are provided, and if the cost is shared by all participants, we do not consider this as a kind of interest. But if there's an election meeting, whoever pays, it should be counted in the electoral expenses or donations. As for media reporting, that may be your concern, and that's about the principle of fair and equal treatment. Like other elections, the definition of a candidate is that a person has submitted the nomination form and accepted by the electoral officer or election officer. In some sectors, there may be many candidates, and so all the names may not be able to be mentioned at one go in a single feature program. Now, there was such a situation in the Electoral Election Committee constituency. We also noticed that in the KFR election of market towns of Cheungchao and Pingchao, a similar situation occurs, and therefore we allow the mentioning of the total number of candidates of the same market town during the program or in the publication, and mention the platform maintained by the media. But please be reminded, this is only applicable to the KFR election of the market towns. For the IR election and the RER elections, the rule is not applicable.
And in the previous case, a loud hailer was used for electioneering in a public area. However, there was a situation where the amplifier or the loudspeaker was actually quite close to the traffic light audio signals for the visually impaired, and hence the amplified sound caused interference to the visually impaired in using this service. So we're banning that. And also, if the public vehicles and other vehicles have election advertisements put on the bodies of the vehicles, then they must not drive near the area, or they will have to remove the advertisement first. In terms of exit polls, we have updated the requirement such that the interviewing party cannot keep the particulars of the respondents, and the personal particulars must not be kept for electioneering activities. Well, of course, if the person is an authorized election expenses agent, then no authority will be granted for the person to conduct exit poll interviews. Another requirement in relation to the receipt for claiming election expenses, the limit to be raised from $100 to $500. As for application for exemption on the de minimis rule, the limit of errors have increased from $200 to $600, and also the Election Corrupt and Illegal Conduct Ordinance has been amended to the effect that there is an offense of inciting another person to cast a blank vote or not to vote for a candidate. We have reminded the public of the new offense, and anyone attempting to commit these offenses would be breaching the law. As for such illegal conduct, the sentences meted out by the court will reflect the seriousness of the offenses. Again, we've mentioned the two cases. Stating that if a person gives support to a candidate, then written consent should be obtained in advance for the name to be dropped in the election materials. And according to the case law, the name of the supporter should be shown categorically in a single document instead of a series of correspondences for the name to appear on the election advertisement. From today to the 9th of August, we welcome comments on the proposed guidelines during this public consultation period. www.eac.gov.hk. If you go to this website, or the www.eac.hk, you will find the proposed guidelines, and you can also approach the Home Affairs Inquiry Centers of district offices. For comments and submissions, you may wish to email us to at the email address. And the EAC will also hold a public forum on the proposed guidelines from 7 to 8 p.m. on the 21st of July at Long Hang Estate Community Center, Sha Tin. Members of the public are invited to attend the forum to express their views. And of course, we will consider all views submitted duly. We seek to revise the set of guidelines, and the guidelines will be formally published later this year. So views are welcome. Thank you. Thank you, Chairman. The floor is now open. Please introduce the media outlet you represent and your name before you speak. This reporter in white. I'm from Cable News. about oath taking. Previously, there was a suggestion on face-to-face oath taking. Would you consider that? And on eligibility review, will this be carried out as well? On the matter of oath taking is for taking up an office. The Electoral Affairs Commission governs the electoral procedures, and once a candidate is returned, the procedures of the candidates assuming office do not fall under the EAC's purview. But in general, legally speaking, as far as the law is concerned, an oral oath and a written declaration or affirmation carry the same binding effect. And it's for the returning officer to decide on the validity of a nomination. But according to the NPCSC's decision, the validity of the nomination for a CE election, Electoral election, or is left for the RUO to decide, but the NPC's decision does not cover a rural representative election. So since there is no mentioning, we're making clear that under the law they are required to make a declaration on upholding the basic law and bearing allegiance to the Hong Kong SAR, and the returning officer will continue to duly check the declarations. Next question. This reporter in the second row. I'm from Phoenix TV. Good afternoon. You mentioned just now that the returning officer will conduct checking according to the law. So what will the returning officer consider? Will he consider the positive and negative lists that they use in the Electoral election and the CE election? And if a candidate is subsequently found to have breached the declaration or the oath, then he shall be disqualified, but which party will be responsible for that? As for validity of the nomination, apart from the NPC's decision, Cap 1 of the laws of Hong Kong, the IGCO, that is Interpretation and General Clauses Ordinance, also has a clear provision about what you mentioned. Second, a number of cases have been taken to court, and the court has decided that a nomination must be made in good faith. So according to the relevant case laws and the laws concerned, the validity of the nomination can be determined in this manner. And as I explained, the subsequent procedures are not part of the EAC's ambit. I think it's for the relevant bureau or department to explain this. Next question, the fourth row, this reporter in white. So there is no eligibility review for this election, and there is no more confirmation form, and it's only for the returning officer to decide whether the candidate's nomination is valid. According to a lawmaker, this should be reviewed. Will you consider that? And also, if the epidemic continues to rage on, by the end of the year, say if we still have several thousand cases a day, is there an alternative plan? And also for a question for Mr. Justice Fung, your term will end by next month. Can you confirm whether there will be another term? For the confirmation form used in the previous elections, it contains an explanation on the candidate's understanding of the legal requirements and the responsibilities concerned. And since then, the law has been amended in terms of the requirement of upholding the basic law and bearing allegiance to the Hong Kong SAR, there are clear provisions in the laws of Hong Kong, and that is, as I answered the previous reporter's question, in Cap 1, the Interpretation and General Clauses Ordinance, which also includes a positive and negative list. And now what we require is for the candidate to fully understand the legal requirements before signing the declaration. And in this sense, the declaration already covers the necessary legislative amendments. So by signing the declaration, it means the candidate clearly understands that it should be done in good faith, otherwise he will bear legal consequence. As for the epidemic situation, by the beginning of next year, well, I'm afraid I don't have a crystal ball. Of course, we do keep in view the situation, and we know that the current term of government are introducing measures and with greater precision. So we'll see how things go by then.
As for my term, according to the law, the chairman of the EAC has to be taken up by an incumbent court justice of the law, and that the person is to be appointed by the CE. I have no comment on this. The one in green in the third row from the Economic Journal. The nomination form will have references to the upholding basic law and the bearing allegiance to the Hong Kong SAR. It's rather technical. Where can we find that? And also for accounting arrangement and voting station arrangement. Under certain circumstances, exit polls are not allowed. Is it because of the law or because of previous elections? Some people doing exit poll didn't comply. Concerning your term, so I just want to know, your term is about to end. Having so many years of experience, can you share with us some of your feelings since you have experienced so many elections? As for the nomination form, it has to be published yet. And we are to publish the nomination form nearer to the nomination period. As for exit poll, the EAC regulates the conduct in the no canvassing zone. If you conduct an exit poll in a no canvassing poll, we regulate that. According to existing law, anything outside the no canvassing zone, any kind of opinion poll is not within the remit of the EAC. Now, since the no canvassing zone is regulated by us, we follow certain standards. We take into account the applicant for the polling exit poll as to whether that applicant is related to the candidates or political groups of the candidates. In the new amendment, we consider whether that will cause any embarrassment to the EAC. After we have approved the exit poll, people may question us why we give the approval, and that will lead to unnecessary disputes. The EAC, in considering such an embarrassing situation, will consider the background of the applicant, previous activities, the person's position, and the person's links. And that has extended the coverage, because in the past we only considered the relation between the applicant and the relation with the political parties of the candidate. We want to avoid any controversy. We want to have a good election, a fair election. We don't want to be seen to be biased. So those non-controversial applicants will continue to give approvals. As for my term of office, I've already answered the question. You can look at the introduction of the various versions of the guidelines on electoral activities and also the recommendations. They are all written by me, so you know all that. You can know all that. The one in gray.
Why the Commission has proposed to combine the nomination form and the allegiance declaration form into one. What will be listed in the nomination form to make sure the candidates will be candidates to understand the consequences if they cannot uphold the basic law? Thank you.
The nomination form has all along contained two declarations. One, to uphold the basic law. Two, to swear allegiance to the Hong Kong SAR. They have always been there for a long time. There come about a point where we see it that there's a necessity to explain to the candidates or the intended candidates to fully understand the basis as well as the consequence of these two declarations. Hence, we issued a confirmation form principally to explain to them the basis and consequences of signing the two declarations. But since then, the situation has moved on. We have the decisions of the National People's Congress, which has entailed amendments of our law, especially Chapter 1, the Interpretation and General Clauses Ordinance, which has set out what are the basis and the consequences, and also instances of not upholding the basic law, etc. And also the confirmation form now has set out in footnotes the relevant statutory provisions. That's why they need only to sign one comprehensive document, which is the nomination form, and all the explanation and consequences has been fully and clearly set out, and hence there is no need to sign separately confirmation, or you could say that the confirmation form is now subsumed into the electoral documents of the nomination form.
仲有冇其他問題？
Any further questions? The one in pink at the back. I'm from TVB. My question is about the nomination form. Now you list out the requirements that the candidate will have to pay allegiance to the basic law is different from having two forms. Will there be candidates who have overlooked the amendment? How will you step up your publicity to remind the candidates they have to confirm bearing allegiance to the HKSAR? The second question is on the EPR in remote polling stations in the new territories. Such a form, such a register couldn't be used. So how can you make sure that it can be used? As for the two declarations in the nomination form, i.e. Upholding the basic law and bearing allegiance to the HKSAR, they have been there all the time. Anyone signing a legal document, in particular a statement or a declaration, that has consequences, one has to be very careful. If they are not careful, we've already explained that to them. If you sign the document, you say, I don't care, I don't know. If you explain that before the court, do you think that's a reasonable explanation? Now, since you're so interested in publicity, I think if you write more about it, it will help us a lot and explain that to the candidates or would-be candidates. As for the EPR, it requires the amendment of the law. If there's a chance to amend the law, then we will take steps to do that at one go. We provide the foundation for that. In the actual arrangement, when we thought about it, when we put that before the Council, when we consider the electoral election, there were no coverage. And in fact, your colleagues did ask similar questions at other press conferences. We have to make sure that it is foolproof before we use it.
And as explained just now, the majority of polling stations for the rural representative election do not involve a lot of voters or ballot issuing desks. So the benefits of the e-poll register would be limited. With
資源咯，因為你喺鄉郊選舉始終個選民基礎冇話立法會選舉咁多咧，我哋動多啲資源咧，係民政事務局咧就話係做得到嘅。咁所以咧係經過衡量呢個可靠性同埋對選民係會唔會有嚟不便嘅咧，我哋就話都係要可靠行先。咁不便嗰度咧，即係比起立法會選舉嚟講咧，呢、個就係冇咁嚴重咧，所以我哋係作呢啲，即係你任何公共嘅決定，你都一個衡量，幫到邊個唔幫到邊個，有啲咩好處有咩壞處，咁我哋覺得呢個都要好安全咁樣做咧，我哋係有信心。咁當然佢研究緊咧，佢就揾專家嘅，咁但係個專家嗰度初步佢。
I understand that there is a professional consultant involved with a deadline, and there are also problems to overcome. Well, I suppose these can be overcome. It's a technical issue, after all. Say if we have a by-election, or perhaps with a lapse of time, with technological advancements, I'm confident that this can be achieved in the future. Any other questions?
TV News. So could the EAC explain the reasons why behind the change about using the same voting station as a ballot counting station?
I have briefly mentioned the combining of the polling and counting. First, this is the mainstreamed method in the geographical constituencies in the electoral elections. The advantage is it saves a lot of logistics as well as time in transporting the ballot boxes from the polling station to the clustered counting station. So I think the target has always been to do it in one day with polling counting. And now we have resolved a lot of the administrative matters, such as we have enlarged the pool of usable polling officers from within the Housing and Youth Bureau to civil service-wise recruitment. And also we have cleared the statutory restraint of that the one returning officer has to see to all the counting. That has been delegated to the various presiding officer of the poll count station. Hence, we are able to move to the target of one-day polling as well as poll count.
Okay. One final question. Any other questions? If not, then that's the end of today's press conference. Thank you. Thank you, everyone.